So there is now a definition for employee in the Fair Work Act. There never used to be. It used to be just the common usage of the term was how it was applied. But now, I think it's possibly created more problems than it intended to, but the definition of employee has recently been interpreted in the court to have quite a broad standing and has included an employee that was situated in the Philippines and has never been in Australia as a citizen or a worker in Australia, was effectively an outsourced employee. These people were not previously covered under the Fair Work Act, but the changes were brought in August 2024. The intent of the changes was to put more clarity around the difference between an employee and a contractor. And what that has done, that the flow on from that definition is a provision around the difference between employees and contractors, and that says that the main test for determining whether someone's an employee or a contractor is no longer written into the contract, except in specific circumstances, and the default position for determining whether someone's an employee or a contractor is based on the nature of the work they do, not what the contract says. And the aim of this legislation was to try and avoid sham contracting. The result of the changes in the legislation has been to bring an extraterritorial person under jurisdiction of the Fair Work Act, which is a really interesting result, and I'm sure not the expected result of those changes. What is important for you as an employer is to now review your contracting arrangements. It'll be really clear in a lot of circumstances who your contractors are, but it may be uncertain in some circumstances, particularly if you're engaging sole trader and contractors, as to whether they're an employee or a contractor. And in those circumstances, you'll need to give very careful consideration to what the arrangements and the nature of their work is, not what's written in your contracts.